You're pulling into your apartment complex after a double shift, exhausted and ready to sleep, and your stomach drops when you see a bright yellow piece of paper taped right across your front door. It's a terrifying sight, designed to make you panic and throw your belongings into the street. But before you pack a single box, you need to know what that piece of paper actually means. That piece of paper is usually a notice to quit, which is simply a formal letter from your landlord telling you they want you out. It's a legal warning shot. It's the first step in a strict legal process, but it's not a self-destruct button. The biggest mistake people make at midnight is reading that paper, getting terrified, and leaving before they legally have to. The first question burning in your mind is probably whether the landlord can just kick you out tomorrow. They absolutely can't. They can't legally change the locks, shut off your electricity, or remove your front door. Doing that's called a constructive eviction, which is a fancy legal term for a landlord illegally forcing you out by making the place unlivable. It's a dirty tactic, and it's deeply illegal in almost every jurisdiction. If they try this, you need to call the police, because a landlord can't evict you without a court order, no matter what that piece of paper says. So, how long do you actually have before you've to leave? That depends entirely on the type of notice you received. The most common is a pay or quit notice. This is a piece of paper that says you owe back rent, and you must either pay the exact amount they listed or move out. The grace period on this notice varies wildly by state. In some places, they have to give you a full 14 days to come up with the cash. In other states, it's a much shorter 3-day warning. This time frame is strictly written into your local laws, and the landlord can't shorten it just to be cruel. Another common notice is for breaking a rule in your lease, like having a massive dog in an apartment that doesn't allow pets. This is often called a cure or quit notice. Cure means to fix the problem. You usually have a set number of days, let's say 10 days as an example, to find a new home for the dog. If you actually get rid of the dog within those 10 days, the eviction process completely stops. The landlord can't move forward because you cured the breach. Keep in mind, laws change constantly, and local judges strictly enforce these exact deadlines, so look up the specific number of days for your exact county right now. What happens if you can't pay, or you can't fix the problem, and those days run out? Does the landlord show up with a sheriff the next morning? They can't do that. When that written deadline passes, the landlord still doesn't have the power to physically remove you. They only have the power to take the next legal step, which is filing a formal lawsuit against you. This lawsuit is called an unlawful detainer. An unlawful detainer is the specific court case a landlord files to legally take back their property from a tenant who won't leave. The landlord can't just sneak this court filing in. They have to officially let you know you're being sued. This is called serving you, which is a legal requirement to hand you the court paperwork in a very specific way, sometimes done by a local process server, to guarantee you actually received it. When you get served, you'll get a date to show up at a local courthouse. That court date is incredibly important. If you ignore it, the judge will issue something called a default judgment against you. A default judgment means the landlord automatically wins the case entirely because you didn't show up to defend yourself. Never skip this court date. When you go, the judge will usually ask if you want a trial. You have a right to a trial. If you ask for one, it slows down the entire eviction process, buying you critical extra days or weeks to find a new place. At that trial, you can't just complain to the judge that your landlord is a terrible person. You need a real legal defense. A defense is a specific legal reason why the landlord shouldn't be allowed to evict you. For example, if the pay or quit notice said you owe $1,500, but your bank statements prove you only owe $1,000, you can tell the judge. If the notice lists the wrong amount of money, the landlord's case usually gets thrown out that very second, and they have to start the whole paperwork process over from scratch. Another strong defense is something called retaliation. Retaliation happens when a landlord tries to evict you simply because you enforced a legal right, like calling a city inspector to report a broken heater. If the eviction comes exactly 3 weeks after you reported a massive safety issue, that looks highly retaliatory, and most courts protect tenants from that. Now, let's say you go to court, you explain your situation, but the judge still rules in the landlord's favor. That court ruling gives the landlord a judgment for possession. A judgment for possession is a formal court order stating the landlord is the legal owner of the property and you no longer have any right to live there. Even with this piece of paper in hand, the landlord still can't physically touch you or your stuff. The judge's order doesn't give the landlord superpowers. The landlord can't drag your furniture out to the curb. They have to take that court order to a local sheriff or marshal. The sheriff's office will then post a final, extremely strict notice on your door, giving you maybe 48 hours to get out. This is a writ of possession, which is the absolute final instruction from a judge that tells law enforcement to physically remove you and your property if you're still there when the clock runs out. When the sheriff shows up, it's totally over. You'll be physically removed and your belongings will be tossed out to the curb. That's the exact end of the road, and it's exactly why you want to deal with this long before that writ ever gets taped to your door. If you've been served with an unlawful detainer lawsuit, you need to get a local eviction lawyer immediately. You have a very short window of time to file a formal response with the court, usually less than a week. Eviction law is highly specific to your state, and missing that deadline by even one single day ends your fight. What if the landlord says they don't care about the courts and they're throwing you out this weekend anyway? That's an illegal self-help eviction. A self-help eviction is when a landlord skips the entire court process and takes matters into their own hands by changing the locks or shutting off your water. If they do this, call the police immediately. The police will often force the landlord to let you back into your own home. And keep in mind, if the landlord files a lawsuit but hasn't properly kept up their end of the bargain, you've options. If they're trying to evict you just because you complained about black mold, that's a valid retaliation defense, but you can't expect the judge to read your mind. You must show up, present your evidence, and formally defend yourself. The entire point of this system is to buy you time, but it's incredibly stressful. Every single step of this process has strict deadlines. The notice, the lawsuit, the court date, the final sheriff's warning, they're all connected. If you know the steps, you know exactly how much time you've left to breathe, negotiate, or pack. I want to know about your experiences. Had you ever had a landlord try to bypass the court system and change your locks on you, and how did you handle it? Drop your story in the comments below. If this breakdown helped you understand the terrifying paperwork machine that takes over when rent is late, pass this video along to a coworker or family member who might be stressing over their own housing situation right now. Make sure you subscribe to Scribble Law so you always know the exact rules of the game before life tries to blindside your wallet.